Senator Sheldon Whitehouse just moved to block Todd Blanche's confirmation as Attorney General. He said there is a pending judicial proceeding in Florida regarding whether Blanche and others committed fraud upon the court. He said, fraud upon the court is about as bad as it gets for a legal officer. He said this is the first time that any senior DOJ official has ever been accused of committing fraud on a federal court.
My view is that this is the first time that the Department of Justice, certainly any senior officials in the Department of Justice, have ever been accused of committing fraud on a federal court.
He said the DOJ chose not to respond to the court when the judge reopened the matter. He said it would be bad to confirm a nominee while a contempt inquiry was pending. He said it would be just as bad, if not worse, to confirm Blanche while a fraud on the court inquiry is pending. He said the committee should not go forward until they understand what happened. He said now would be a good time to address it. Let's watch.
Thanks very much, Mr. Chairman. I'd like to take the time that we have here to raise an unrelated issue. You can relax.
Thank you.
We, as a committee, considered the nomination of an individual named Emil Bovee to go on to the Third Circuit Court of Appeals. At the time that we did so, there was a pending proceeding in federal court, an inquiry into whether Mr. Bovee and others had committed contempt of court. That proceeding was stayed by an order by two Trump appointees on the D.C. Circuit. They used a device called an administrative stay, which I think lawyers know customarily is a device to hold the status quo for a short period of time, maybe a week or two, sometimes only hours. The two Trump appointees kept this administrative stay in place for 4 months. And it was during that period of the stayed contempt proceeding involving now Judge Bovee that this committee put him through his confirmation and sent him to the floor. I think in ordinary circumstances, we would have said, wait a minute, there's a contempt proceeding pending against this individual. We should find out about that before we put him on a circuit court of appeals. But these are not ordinary times. And so Mr. Bovee was hustled through the confirmation process, and then the stay was lifted. The D.C. Circuit told the D.C. district judge, you can now go forward with the contempt proceeding. One of the same Trump judges with another Trump judge then stayed it a second time. And the D.C. Circuit has just announced that it will consider overturning that stay en banc. So that saga is going to continue. But I don't think it was a high point in the Judiciary Committee's history to put a candidate through the confirmation process with a contempt of court inquiry undecided. Now we're moving forward into Todd Blanche and his potential confirmation as Attorney General of the United States. Well, right now, there is a judicial proceeding pending in Florida regarding whether Blanche and other Confederates committed fraud upon the court in that federal district court. Just as a brief aside, fraud upon the court is about as bad as it gets for a legal officer. You can be sanctioned and disciplined for misconduct, for acting out in court, various things. You can go to being held in contempt of court, which is pretty darned serious. But fraud on the court stands apart as an allegation. My view is that this is the first time that the Department of Justice, certainly any senior officials in the Department of Justice, have ever been accused of committing fraud on a federal court. And that matter is pending down in Florida. Interestingly, the Department of Justice chose not to respond to the court when the court said, yeah, I'm going to reopen this matter and let's take a look at this. Fraud on the court for the first time in the department's history, you'd think they'd want to respond to that. Specific question about whether the actions of the DOJ comported with its own policies, something DOJ would know about. And then what about a defense memo offered by the client, the Internal Revenue Service, again, something the DOJ would know about. And the gravamen of the issue is collusion, which takes two people on both sides of the case. So only the lawyers for Trump, his personal lawyers, answered. Despite all of those apparent invitations from the judge, the DOJ didn't answer. So we have no sense yet of what's going on. Looks like Judge Williams is going to continue that investigation. But I just think, bad as it was, to confirm a nominee to a Circuit Court of Appeals while a contempt of court inquiry was pending against that exact individual, it would be just as bad, if not worse, to go forward with Blanche's confirmation while a fraud on the court inquiry is pending against him. We have asked for documents related to that first episode, and I am asking again because we don't get a response out of the Department of Justice when we ask for documents. And I hope that we can look into this adequately to be prepared for questioning when we end up going forward. But we're in a pretty terrific position to require answers from the Department of Justice by simply saying, look, we're not going forward until we understand what the heck happened here. And if you're not answering to a federal court, well, you ought to consider answering to us as we deal with your confirmation proceedings. So I've gone a minute over my time, and it's not, again, not relevant to the candidate before us, but I did want to have a chance to make this point publicly because we're going to have to address this, and now would be a good time. Thank you very much, Chairman.
Thank you.
Senator Sheldon Whitehouse just delivered a masterclass in how to use a committee hearing to expose a pattern of questionable judicial confirmations and to lay the groundwork for blocking a nominee. He did not come with a speech. He came with a precedent. He came with a pattern. He came with a pending fraud on the court allegation, and he left no doubt about the answer. The exchange was not just a routine hearing. It was a warning. It was a call for accountability. It was a demand for answers. It was a declaration that the Senate Judiciary Committee would not simply rubber stamp another controversial nominee without understanding the full scope of the legal issues surrounding them. Whitehouse began by recalling a previous confirmation. He said the committee considered the nomination of Emil Bove to the Third Circuit Court of Appeals. At the time, there was a pending contempt proceeding against Bove. 2 Trump appointees on the D.C. Circuit used an administrative stay to put the proceeding on hold. Administrative stays are supposed to be short, a week or 2, sometimes only hours. They kept it in place for 4 months. During that period, the committee put Bove through his confirmation and sent him to the floor. Whitehouse said that in ordinary circumstances, the committee would have waited. It would have wanted to know about the contempt proceeding. But these are not ordinary times. Bove was hustled through. The stay was lifted. The proceeding continued. Whitehouse said it was not a high point in the committee's history. The committee had failed in its duty to fully vet a nominee. It had allowed a judicial appointment to proceed while serious questions about the nominee's conduct remained unanswered. That was a mistake, and Whitehouse was determined not to repeat it. Then Whitehouse turned to Todd Blanche. He said there is a pending judicial proceeding in Florida regarding whether Blanche and others committed fraud upon the court. He explained that fraud upon the court is about as bad as it gets for a legal officer. Contempt is serious. Misconduct is serious. But fraud on the court stands apart. It is the most serious allegation a legal officer can face. It involves deceiving the court itself, undermining the integrity of the judicial process. Whitehouse said this is the first time that any senior DOJ official has ever been accused of committing fraud on a federal court. That is not a minor allegation. That is a historic one. The Department of Justice, the very institution that enforces the law, is now facing allegations that it violated the law in the most serious way possible. Whitehouse said the DOJ chose not to respond to the court when the judge reopened the matter. The judge asked questions. The DOJ did not answer. Only Trump's personal lawyers answered. Whitehouse said the committee has asked for documents, but the DOJ has not responded. He said the committee should not go forward until it understands what happened. Whitehouse's argument is devastating. He did not need to prove the allegations against Blanche. He only needed to show that the committee should not confirm him while a fraud on the court inquiry is pending. He showed that the committee has a history of rushing confirmations while legal proceedings are pending. He showed that the DOJ is not answering questions. He showed that the committee is not getting the documents it needs. He showed that the committee should not repeat the mistake it made with Bove. He showed that the committee should demand answers before moving forward. The committee has a constitutional duty to provide advice and consent on nominations. That duty cannot be fulfilled if the committee does not have all the relevant information. Whitehouse was arguing that the committee should not proceed until it has that information. That is not obstruction. That is oversight. The pattern is clear. First Bove, now Blanche. In both cases, there were pending legal proceedings. In both cases, the committee moved forward anyway. In both cases, the DOJ did not provide answers. Whitehouse called it out. He said the committee should not make the same mistake twice. He said the committee should not confirm Blanche until the fraud on the court inquiry is resolved. He said the committee should use its power to demand answers. He said now would be a good time to address it. The time for waiting is over. The time for demanding answers is now. The committee should not be bullied or rushed into confirming someone with such serious allegations hanging over their head. Whitehouse's voice lands differently because of who he is. He is a former prosecutor. He is a former state attorney general. He knows what fraud on the court means. He knows how serious it is. He knows that the Department of Justice should not be above the law. He knows that the Senate should not confirm someone who is under investigation for fraud on the court. He is not making this up. He is not exaggerating. He is presenting facts, and the facts are damning. He has spent years on the Judiciary Committee. He has seen countless nominations. He knows when something is wrong, and he is sounding the alarm. Fraud on the court is not a technicality. It is not a minor infraction. It is an attack on the integrity of the judicial system itself. And if a nominee is accused of it, the Senate has a duty to investigate before confirming them. The larger issue here is not just about Blanche. It is about the integrity of the confirmation process. It is about whether the Senate will do its job. It is about whether the Senate will hold nominees accountable. Whitehouse argued that it should. He argued that the committee should not rush confirmations. He argued that the committee should demand answers. He argued that the committee should not confirm someone with a pending fraud on the court inquiry. He was right. The confirmation process is not a formality. It is a constitutional responsibility. The Senate is supposed to provide advice and consent. It cannot do that if it does not have the facts. It cannot do that if it is rushed. It cannot do that if the DOJ refuses to answer questions. Whitehouse was calling on his colleagues to fulfill their constitutional duty. The hearing ended without a resolution. The committee did not vote on Blanche. Whitehouse made his point. He made it clear that the committee should not go forward until it understands what happened. He made it clear that the DOJ should answer questions. He made it clear that the American people deserve better. The question now is whether the committee will listen. Will it demand answers? Will it insist on transparency? Will it do its job? Or will it repeat the mistake it made with Bove? The answer to that question will determine whether the confirmation process is a serious exercise in constitutional governance or a rubber stamp for the executive branch. Whitehouse has done his part. Now it is up to his colleagues.